Hi everyone, and welcome to today's webinar, Emerging Human Rights Due Diligence Regulations Across the Globe. A little bit of orientation about the webinar platform before I introduce our speakers for today. The webinar slides are available to the left side of your screen, along with a few helpful links if you would like to explore and learn more about compliance and risks and how we can help simplify and accelerate your compliance processes. We want this webinar to be as engaging as possible, so please do send us any questions you may have and we'll aim to address them during the Q&A session at the end of the webinar. And if you would like to submit a question for this Q&A session, please use the Ask a Question widget on the left side of your screen. And we'll also follow up with you directly for any questions we don't get to during today's session. At any time, if you're interested in having a member of our team follow up with you outside of this Q&A function, please use the Start a Conversation button at the bottom of your screen. And last but not least, the webinar recording will be sent to you within 24 hours. My name is Orla Morris and I'm the Content Marketing Manager here at Compliance and Risks, and I'm delighted to be joined today by Joanne O'Donnell, Hannah Yanknecht and Christian Barroso. So starting with Joanne heads up a team of over 40 international product regulatory specialists at Compliance and Risks. She qualified as a lawyer in Ireland in 2003 and has extensive legal experience spanning private practice, in-house and industry at both national and international levels, including the United Nations. Joanne has worked with compliance and risks for over 14 years and has a particular interest and focus on sustainability, human rights, and ESG. Thank you so much for joining us today, Joanne.
Thanks, Orla. Thank you. Delighted to be here.
And moving on to Hannah. Hannah joined the team in compliance and risks as a regulatory specialist in September of 2022. She's responsible for the monitoring of developments in German-speaking countries and is a subject matter expert for sustainability reporting, supply chain due diligence, and textiles compliance. Thank you so much for joining us today, Hannah.
Thank you, Orla, and welcome everyone.
And last but not least, Christian is a regulatory compliance specialist with over 9 years of experience in environmental compliance and human rights. Joining the team at Compliance and Risks in April of 2024, he's a subject matter expert in human rights, human trafficking and slavery, circular economy, WEEE, and more. Thank you for joining us today, Christian.
Thanks, Orla. Happy to be here. Welcome, everyone.
Brilliant. So before we kick off the webinar, I would like to just very quickly provide a background about compliance and risks for those who are joining this series for the first time. At Compliance and Risks, our mission is to help ensure global companies have the tools and information to build safe, sustainable products in a world full of change. We are the trusted product compliance technology provider for the world's leading brands and have spent 2 decades honing the digital tools, expertise, and content you need to stay ahead of the dynamic regulatory landscape and prove your product's compliance, protecting your brands and helping to drive your growth. At Compliance and Risks, we have the world's most comprehensive regulatory database with over 100,000 regulations historically available in C2P. With a global regulatory coverage and expertise across over 10 industries, we understand that regulatory compliance definitely doesn't sleep. And our regulatory expert team is truly global, with 28 languages collectively spoken across the team, all fortified by our 13 knowledge partners. C2P is our enterprise software designed to keep global organizations on top of regulatory changes and their impact worldwide. This includes early warning alerts, impact probability, productivity workflow tools, and so much more. And with that, I'm delighted to hand it over to you, Joanne.
Thank you, Orla. Thank you so much. Okay, so let's get stuck in. So welcome everyone, and thank you so much for joining our session today on human rights due diligence obligations around the world. Really delighted you could all join us on this Wednesday afternoon or Wednesday morning, depending where you are. This is, it's one of the most rapidly evolving areas in regulatory compliance, human rights due diligence regulations, and it's kind of reshaping corporate accountability in real time. So we have a real jam-packed agenda for you all today. So along with Hannah and Christian, we're going to do a real whistle-stop tour of key existing and emerging regulations in this space across a broad range of regions, from Europe to the US, Canada, Asia, Australia, New Zealand, and South America. And then we're going to touch upon some developments in the UN as well. So, and then I'm going to close out the session at the very end with a short recap of just some key takeaways that you can consider. But first up, I think it's really important, I suppose, to set the scene and to kind of ground us a little. And I think a really important starting point is for us to look at the evolution of human rights due diligence regulations to see how these types of laws and regulations have slowly, over the past number of years, evolved from what were largely seen as voluntary measures to more mandatory measures across the globe. So for many, many years, human rights obligations were largely set out in various international treaties and national laws, and they were viewed largely as being only applicable to countries. In 2005, the former UN Secretary General Kofi Annan, he appointed John Ruggie as the UN Special Representative to look into adopting a framework for corporate human rights duties, which went beyond the voluntary measures that were in place up until that point. And this ultimately led to the adoption in 2011 of the UN Guiding Principles on Business and Human Rights, which you can see here on the slide on the far left. And they really were the starting point for mandatory human rights due diligence across the globe. And in many respects, they still remain very much a foundational and really important part of those regulations as well. So as you can see from the timeline here, particularly some of the EU measures, human rights due diligence has evolved from a very voluntary set of principles to a mandatory set of obligations with some serious consequences for non-compliance. So let's just take a quick look before I pass you over to Hannah as to what caused this evolution. 2013, the Rana Plaza tragedy was the real turning point in corporate accountability for human rights. This was a tragedy, a factory collapse in Bangladesh that killed over 1,100 garment workers. And it really exposed the reality of the consequences of unchecked supply chains. It showed the world and it showed regulators that the voluntary measures that had been in place up until that point had really, really failed to prevent these systemic human rights abuses that unfolded. And it really, really highlighted how large corporations, many of whom were based here in Europe, were sourcing from factories with totally unsafe working conditions, weak, if non-existent regulation, and a total lack of transparency in their value chain. So in the wake of that disaster, civil society, trade unions, policymakers, regulators, they argued that companies should really not just focus on human rights abuses in their direct operations, but also in their entire supply chain, their suppliers and their subcontractors. So that pressure made the transparency of non-financial information, including information in supply chains, a much more urgent topic for the EU. And that led ultimately to the adoption of the Non-Financial Reporting Directive in 2014, which some of you may know was the precursor to the Corporate Sustainability Reporting Directive that we all know today. So, that's kind of a roundabout way to kind of summarize that what started very much as a voluntary guidance under the Guiding Principles on Business and Human Rights in 2011 has since evolved into a global wave of mandatory human rights and due diligence obligations, which Christian and Hannah will touch upon shortly. So what is human rights due diligence? And really, in order to understand this concept, we really have to look to the UNGPs themselves, the UN Guiding Principles, because they're really crucial in understanding the concept. So in many of the regulations that Hannah and Christian are going to touch upon shortly, refer specifically to these guiding principles, along with another set of voluntary principles from the OECD, known as the OECD Guidelines for Responsible Business Conduct. Those two sets of guidelines, whilst they are voluntary, they very, very much form the framework and the foundations of all of the existing mandatory regulations that we will look at shortly. So the UNGPs themselves are based on three main principles. The first one is the state's duty to protect against human rights abuses by corporations, and they do that through implementing effective policies and regulations. The second principle is the corporate responsibility to respect those human rights and to conduct human rights due diligence. And then the third principle is access to remedies. So there has to be access to effective remedies, both judicial and non-judicial, for those whose rights have been violated. So as Hannah and Christian are going to demonstrate, these three principles are the foundation of many of the different types of mandatory human rights due diligence regulations that have emerged across the globe. And before I pass you over to Hannah and Christian, you will see a real kind of, I suppose, thread across all of the regulations that we will cover, is the fact that there are three main kind of categories of human rights regulations. So the first type are the corporate disclosures. They're the most common, and they're the ones that we've historically seen. These would be examples would be the UK Modern Slavery Act or the Australian Modern Slavery Act. And they essentially require companies just to publish information or to report out on any human rights due diligence processes or outcomes that they have in place. It doesn't require them to implement those processes. It just requires them to report on any human rights due diligence processes that they may have in place. And if they don't have them in place, they have to include that in the report as well. The next set of human rights due diligence laws that we will see are those that require and contain a concrete obligation to perform human rights and in some cases environmental due diligence. And those laws and the infamous CSDDD, or the Corporate Sustainability Due Diligence Directive, is one example, as well as the French Vigilance Law and the German Transparency in Supply Chains Act. They contain actual obligations for companies to undertake human rights due diligence. And then the final set of laws that we will see, they're a newer type of law. They're more trade-based, and they contain a complete prohibition on the import, export, and or placing on the market of products associated with certain risks, for example, forced labour or child labour. And the most recent examples of those are the forced labour regulation here in the EU and the Uyghur Forced Labour Prevention Act in the US. So they might not necessarily contain overt obligations to have a human rights due diligence process in place, but in order to comply with those laws, you need to have a really robust human rights due diligence process. So on that note, I'm going to pass you over to Hannah, who's going to kick off with what's happening in the EU. So Hannah, over to you.
Oh, sorry, I was a little bit too fast there. Thank you, Joanne, for this great introduction. And I'm now going to continue with some details on human rights due diligence in the European Union, in the United States, and in Canada. So as Joanne said, at the core of human rights due diligence in the European Union stands, of course, the Corporate Sustainability Due Diligence Directive, short CSDDD. And I guess by now everyone directly concerned by the CSDDD is probably very familiar with the core obligations, so I will just recap them very quickly. The CSDDD came into force in July last year, and member states have until July 2027 to implement the directive into national law. The obligations for companies will then be phased in between 2028 and 2029, depending on the number of employees and the turnover of the company. The CSDDD applies to both EU companies as well as large non-EU companies. And in its current form, it requires companies to integrate due diligence into their policies and management systems to identify, prevent, mitigate, and account for adverse human rights and environmental impacts across their own operations, subsidiaries, and value chains. Even though the CSDDD was watered down quite a lot before its adoption in 2024, it still represented a big step forward for mandatory human rights due diligence. But in February 2025, the EU Commission proposed another round of changes to the CSDDD and a number of other corporate sustainability laws as well, which is known as the Omnibus Simplification Package. The first part of this Omnibus Package, the Stop the Clock Amendment, already entered into force in April 2025. And for the CSDDD, this basically meant that the largest companies, which are those with 5,000 employees and more than 1.5 billion in turnover, got 1 additional year to comply with the CSDDD. And then member state implementation was also pushed out by 1 year. And both of those dates were already taken into account on the previous slide as well. The second part of the CSDDD amendments, the so-called content proposal, is however not yet finalized. And as you can see here in the table on the slide, the Commission proposed changes to the due diligence obligations, climate transition plans, and also the liability regime of the CSDDD. And then the Council negotiating position from June and the position of the EP Jury Committee from October go even beyond what was proposed by the Commission. We're going to have a quick look at the positions of the 3 institutions now, but just with the caveat that the EP plenary rejected the EP jury's position 2 hours ago today, so it's not clear yet if this is going to be the final EP position. So while the Commission did not propose any changes to the scope, both Council and Parliament suggest to reduce the scope of the CSDDD to companies with more than 5,000 employees and 1.5 billion turnover, which means that essentially only the largest companies of Wave 1 will be subject to mandatory due diligence, with some sources stating that this could lead to a cut of up to 70% of the current scope. So this is a quite drastic change. Then regarding Article 8, which sets out how companies have to conduct due diligence, the Commission suggested to reduce due diligence to the first tier of the supply chain, which is direct suppliers and business partners. And then companies would only have to look beyond this if there is actually plausible information that suggests human rights and environmental violations are taking place further down in the supply chain. The EP Jury Committee position, on the other hand, suggested a fully risk-based approach, which does not limit due diligence to the first tier and requires companies to look beyond that at the most severe and most likely risks. But this will also be limited by a value chain cap, which essentially limits the information companies can request from smaller companies in their supply chain to the kind of information that is strictly necessary and that cannot be obtained through other sources. Since the ideas of all 3 institutions on Article 8 are quite different, this is likely going to be one of the major discussion points in the trilogue negotiations. And then all 3 positions also suggest to maintain the obligation to adopt climate transition plans, but companies will no longer be legally required to ensure the implementation, even though the Commission and Council position at least require implementing actions to be outlined in the plan. And then last but not least, all 3 institutions also propose to delete harmonized liability, which means that the member states' own non-harmonized liability laws will apply, which will likely lead to 27 different liability regimes and most likely more uncertainty for companies. Just to have a quick look at what's coming down the line. So while the EP Jury Committee was hoping to get a mandate to start trilogue negotiations with the Council and Commission this week already, the EP plenary actually rejected this mandate just 2 hours ago today. So now the full plenary will have to vote on the EP position on 13th of November. And it's likely not going to be easy to find majorities and common ground here. And we're definitely going to keep a very close eye on any future developments here. Then the 3 institutions are hoping to finalize the trilogue negotiations before the end of the year to kind of finally achieve some clarity for companies, but it's not fully clear if this is going to be possible or not. So having the CSDDD on one side, which covers all sectors and industries, the EU has also several sector-specific laws that require human rights due diligence, and the oldest one here is the Conflict Minerals Regulation, which already came into force in 2021, and it requires importers of tin, tantalum, tungsten, and gold from conflict-affected and high-risk regions to set up human rights due diligence in line with the OECD guidelines. Then a second very important regulation in this regard is the EU Batteries Regulation, which came into force in July 2023. And in addition to a very comprehensive set of rules on the design, labeling, and waste management of batteries, it also contains human rights and environmental due diligence obligations for manufacturers. So the obligation to set up due diligence policy was originally supposed to become applicable in 2025, but as part of the Omnibus simplification work, it's been pushed out by 2 years to August 2027 now. and the accompanying Commission guidelines will be published 1 year before that in 2026. The due diligence requirements of this regulation really focus on the raw materials that are used in batteries, namely cobalt, lead, lithium, and nickel. And then manufacturers are obliged to identify and address social and environmental risk associated with their sourcing and use. And at the moment, this applies to all manufacturers with more than 40 million annual net turnover, but the EU Commission proposed to increase this to 150 million turnover. But just to note that this change has not yet been finalized. Then last but not least, the EU Deforestation Regulation also requires those placing certain forest commodities or products on the EU market to ensure that they are deforestation-free and produced in accordance with the laws of the country of production and covered by a due diligence statement. And these obligations apply to 7 forest commodities, which are timber, cattle, soy, palm oil, cocoa, coffee, and rubber, and then to a very long list of derived products, for example, packaging, furniture, chocolate, and leather. So under this regulation, operators are required to gather very detailed information on their supply chain, for example, on the geo-coordinates of the plot of land where the commodities have been produced. And then they have to assess and mitigate risks to ensure that no or only a negligible risk of deforestation consists before then placing products on the market. In May 2025, the EU Commission published the so-called benchmarking system that assigns each country a high standard or low risk of deforestation. And this basically determines the amount of checks and the level of due diligence that products are subject to. Overall, this benchmarking system was met with quite a lot of criticism, since only Russia, North Korea, Myanmar, and Belarus were actually assigned a high-risk status, while all EU member states were assigned a low-risk status. But so far, the Commission has not officially reacted to this criticism. And speaking of criticism, the UDR is currently supposed to become applicable for large and medium-sized companies at the end of 2025, and then for small and micro enterprises in June 2026. But just a few weeks ago, the EU Commission was considering another delay of the entire UDR by 1 year. But it has now actually reconsidered this. And just yesterday, the Commission proposed changes to the UDR that will mostly affect smaller companies, who will now potentially get 6 months longer to comply and are subject to reduced reporting obligations. And then the obligations for large and medium-sized companies are not supposed to be postponed, but a 6 month grace period for checks and penalties is proposed instead. But this Commission proposal needs to be approved in the Council and in the Parliament before it can go ahead, so things will certainly remain very interesting in this space. Then in addition to these kind of sector-specific human rights due diligence laws, the EU also adopted another more sector-agnostic law to assure that products placed on the market are not manufactured using forced labor. And this regulation banning products made using forced labor already entered into force in December 2024, but the ban will become effective in December 2027, so companies have a little bit of time to prepare for this. And just to note, the ban is very broad in scope, since it will apply to all products regardless of their origin, and also to all companies of all sizes. The regulation itself does not impose any specific obligations on companies other than to ensure that the products have not been made using forced labor, but it strongly encourages companies to implement strong due diligence practices. And this is especially important, of course, for companies that are not currently in scope of, for example, the CSDDD or other due diligence laws, and for whom this is basically a new indirect obligation to conduct due diligence. Then under this regulation, the onus to prove that forced labor has taken place is with the authorities that enforce the ban. So this is either the EU Commission or national authorities, depending on where the products come from. And to support companies in their preparation, the EU Commission will publish due diligence guidelines and best practice guidelines in June 2026. So that's something to look out for. And also establish an indicative database with high-risk geographies and high-risk products. So as you can see, while the kind of most far-reaching human rights due diligence laws are currently being implemented at the EU level, some EU member states already adopted due diligence laws long before the CSDDD was even proposed. And the oldest law here is the French law. So France introduced its vigilance law already in 2017. and it requires large companies based in France to set up a vigilance plan addressing both human rights and environmental risks in the supply chain, covering all of the companies that they have established business relationships with. So in terms of enforcement of this law, there is a number of lawsuits currently pending, but only one has actually been finalized so far. And in June 2025, the Paris Court of Appeal upheld a previous decision which found that the vigilance plan of the state-owned postal company was not sufficient. And the court actually established some key points that can be very helpful for other companies reviewing their vigilance plans as well. So it determined that the risk assessment must be, for example, tailored to the company's own business activities rather than relying on broad or generic evaluations. Then instead of addressing every single possible human rights or environmental risk, the risk mapping must also be focused on the most significant threats. And the court also found that the consultation with trade unions, in particular on the company's alert mechanism, was insufficient as well. As I said, several other cases have been declared admissible recently and are pending, which shows that there is definitely a will to enforce this law, and companies are well advised to review and strengthen their policies to avoid litigation. The German due diligence and supply chains law and German Lieferketten-Sorgfaltspflichtengesetz came into force in 2023, a little bit later. And it requires German-based companies with more than 1,000 employees to implement human rights due diligence. In April 2025, just a few months ago, the German government announced its intention to repeal this act and replace it with the national implementation of the CSDDD as soon as the Omnibus negotiations are finalized. And in a first step, the government already proposed an amendment to the law in September 2025, which would basically remove the annual reporting obligations and also reduce the application of sanctions to serious violations of the law, such as, for example, the failure to implement a grievance mechanism. And even though these amendments have not yet been adopted by the parliament, the enforcement agency already changed its enforcement practice in October, and it's no longer checking the submission of reports or handing out sanctions for violations other than serious violations. So now just a very quick look at outside of the European Union. So Norway already adopted its Transparency Act in 2022, which requires both large Norwegian companies and foreign companies active in Norway to conduct human rights due diligence and to submit an annual report. And so far, there have actually been no major changes to this law. And in August 2025, a government report actually found that this law has indeed led to concrete improvements in the way businesses prioritize human rights due diligence. And companies participating in the survey were generally found to be supportive of the law as well. When we look to Switzerland, on the other hand, there is currently no comprehensive mandatory human rights due diligence law, and the due diligence and reporting obligations that were enacted in 2022 really focus only on conflict minerals and the prevention of child labor in the supply chain. But in September 2025, the Federal Council in Switzerland announced that it is working on a broader due diligence law that will be based on EU and international standards. And this new initiative will be an indirect counter-proposal to a recent popular initiative in Switzerland that asked for stricter business and human rights regulations. And a first draft of this will become available in March 2026. As soon as more clarity has been reached on the EU's Omnibus negotiations. So this is definitely something to keep an eye on for all companies that are active in the Swiss market as well. So at the same time, when we look at the UK, so the UK seems to stand a bit at a crossroad when it comes to human rights due diligence at the moment. The UK Modern Slavery Act was considered groundbreaking when it was introduced in 2015. But since then, the UK seems to have fallen behind a little bit. So the UK Act only focuses on reporting through the Modern Slavery Statement, which means that companies are not formally required to implement due diligence measures. And there's also quite some flexibility in the content of the statement as well. And in response to this, a parliamentary report from July this year recommended the introduction of real human rights due diligence obligations, alongside a ban on products made with forced labor and increased accountability for companies. The government has acknowledged the report, and it's also announced an inquiry into strengthening obligations for companies. So now kind of moving on to the regulatory landscape in the United States. So in the United States, the landscape is, of course, a lot more fragmented between federal and state level. Specifically for conflict minerals, the Dodd-Frank Act from 2012 requires publicly traded companies to be transparent about the use of certain conflict minerals. But other than that, there's currently no comprehensive federal law that would make human rights due diligence mandatory across all sectors and industries. And instead, the United States is focusing more on reducing its reliance, particularly on Chinese supply chains, by introducing laws such as the Uyghur Forced Labor Prevention Act. And the Uyghur Forced Labor Prevention Act is definitely the one kind of core human rights due diligence law to keep an eye on for US companies. This came into effect in June 2022. And it essentially expands the already existing import prohibition for products made with forced labor under Section 1307 of the Terrorist Act by now introducing the rebuttable presumption that all products produced wholly or in part in the Xinjiang region of China or by one of the entities on the entity list have been made using forced labor. The onus to prove that this is not the case lies with the companies that are importing the goods, who have to conduct due diligence of their supply chains to ensure that products have not been made using forced labor. The entity list and also the UFLPA strategy are updated quite regularly, and just in January 2025, for example, 37 additional entities were added. And for companies that are trying to assess their risk under this act, the UFLPA Statistics Board is actually quite a valuable resource. The Statistics Board was last updated in September, so just a few weeks ago, and it shows the sectors that have the most goods detained, released, or ultimately denied. And as you can see here on the slide, the sectors that are most at risk of having goods denied are the automotive, electronics, and apparel sector. And then it's also interesting to note that the majority of the detained shipments is actually not originating directly from China, but rather from Malaysia and Vietnam, which kind of shows that more indirect links to the Xinjiang region, such as the manufacturing of parts of a product, is definitely on the authorities' radar as well. Then in addition to the UFLPA, there's also two other bills that are targeting Chinese supply chains and goods that were allegedly made with forced labor. And these were both introduced in the US Congress this year. They're the Cobalt Supply Chain Act and the Task Act. So the Cobalt Act would be broader than the UFLPA in that it's not restricted to the Xinjiang region, but it rather focuses on the import of cobalt refined anywhere in China. And it's establishing a similar rebuttable presumption to the UFLPA. And cobalt is crucial for the manufacturing of a lot of products, for example, batteries, smartphones, and other electronic devices. And so far, there has not been a lot of movement on this bill, and it's currently pending congressional review. Then there's the second bill, that's the Task Bill, and this focuses more on disclosures rather than an import barrier. And this bill would actually require publicly traded companies to disclose information on imports and activities linked to the Xinjiang region in China. But similarly to the other bill, there is not much movement on this bill either yet. Then another Senate bill that is quite important was proposed in March 2025. And this bill basically aims to prohibit certain US companies from, such as manufacturing companies as well, from complying with foreign due diligence obligations, also including the EU CSDDD. And while it's not likely that this bill will progress and be signed into law, the US-EU trade agreement that was concluded in July this year did actually address the impact of EU sustainability rules on US companies. And in this agreement, the EU committed to ensuring that the CSDDD, CSRD, EUDR, and CBAM do not pose undue restrictions and burdens on transatlantic trade, and especially on small and medium-sized companies. But the agreement is overall quite vague, and it also points out that there is no plan to grant US companies more favorable conditions or have this agreement limit the EU's autonomous rulemaking. So it remains to be seen how this will actually play out in practice. When we're looking at the state level in the United States, developments on human rights due diligence are overall quite slow. So several states, including Washington and New York, have, for example, proposed fashion sustainability accountability acts in recent months. But the New York bill, for example, only focuses on the environmental impact of the fashion industry. It doesn't focus on social impacts or human rights impacts. And then in addition, there's, for example, also the California Transparency in Supply Chains Act from 2010, but this really also just focuses on disclosures, and it doesn't have any kind of active obligations to introduce supply chain due diligence. So last but not least, Canada enacted the Fighting Against Forced Labor and Child Labor in Supply Chains Act in 2023. And this act requires companies to report annually on the steps they have taken to prevent and reduce the risk of forced child labor in the supply chain. But this act is quite narrow in scope, since it first of all only focuses on disclosures. It does not make supply chain due diligence itself mandatory. And in addition, the act also focuses only on labor rights, while other human rights considerations are not in scope. And since this act here and the UK and Modern Slavery Act and UK and Australian Modern Slavery Act have overall quite similar reporting requirements, the three governments published a joint reporting template in July this year to help companies that are reporting in multiple jurisdictions. And in addition, Canada implemented an import ban on goods made with forced labor in July 2020, which is based on the trade agreement between the US, Canada, and Mexico. So far, the import ban suffers from poor enforcement overall, with only one shipment having been ultimately denied entry since 2020. So last year, in response to this, the government consulted on additional measures to strengthen the import ban, such as the creation of minimum supply chain due diligence measures. And it also announced its intention to propose a mandatory due diligence law. But as of October 2025, there are no details on the draft available yet. And with this, I will hand over to Christian, who will provide insights on human rights due diligence in Asia and South America.
Thanks, Anna. I will just give a quick overview about Asia, South America, and the UN. Asian countries are keeping pace with the implementation of regulatory frameworks on business and human rights, from the development of national action plans with chapters or provisions or corporate responsibility to the publication of bills on human rights due diligence. Countries that have implemented national action plans on business and human rights include Japan, South Korea, China, Thailand, Vietnam, Indonesia, and currently Malaysia. We must consider that national action plans include voluntary provisions or recommendations. Nevertheless, as Joanne said before, there are bases for future or current drafts on mandatory laws. This is also encouraged by international and local pressure from governments, investors, NGOs, and civil society in general, which are demanding stronger and mandatory human rights due diligence frameworks. First, we have South Korea with the Corporate Human Rights and Environmental Due Diligence Bill. Originally introduced in September 2023, this bill was later revised and resubmitted in July 2025. The bill would apply to large companies in Korea with either 500 or more employees or a revenue of at least 200 billion South Korean won, which equals around $140 million US, and would require companies to conduct and implement mandatory human rights and environmental due diligence system, appoint responsible officers for the due diligence implementation, establish grievance and reporting mechanisms, and also to submit a report to the Human Rights and Environmental Business Committee on the negative impacts and mitigation measures implemented, engage with relevant stakeholders when developing a human rights due diligence process, and also to terminate or suspend business relationships when necessary in order to stop human rights violations. Similarly, the Korean Human Rights and Environment Committee is established as the authority in charge of monitoring compliance, ordering companies to implement corrective measures, designating foreign countries as high-risk areas, and investigating complaints. Non-compliance can trigger civil liability, administrative corrective orders, criminal penalties of up to 5 years in prison, or fines of up to 50 million Korean won, which equals approximately of $35,000 US. The draft is currently under the revision of the Planning and Finance Committee. In addition, since 2021, South Korea has had the Guidelines on Business and Human Rights as part of its National Action Plan. These guidelines provide industry-specific recommendations regarding the manufacturing, pharmaceutical, construction, IT, and communication sectors, among others, on how to implement human rights due diligence. Next, Thailand. Online reports indicate that the government is working on a draft law to establish human rights due diligence obligations on Thai and non-Thai large enterprises, with an annual revenue of more than 500 million Thai baht, which equals approximately to 15 million US dollars for the manufacturing sector, or exceeding 300 million Thai baht or which equals 9.3 million US dollars for the wholesale, retail, or service sectors. The human rights and environmental due diligence has to be carried out across its entire value chain to identify, assess, and mitigate risk. For that, companies would be required to adopt a human rights policy, as well as to monitor and report annually on the actions implemented and establish grievance mechanisms. Penalties for non-compliance will range from 500,000 Thai baht or 15,000 US dollars to 5 million Thai baht or 153,000 US dollars. Note that the penalties under this bill would not exempt non-compliant enterprises from other civil or criminal liabilities under other several laws. We don't have to forget that on 8th of September 2023, the Thai government adopted the second National Action Plan on Business and Human Rights for the period 2023 and 2027. The second National Action Plan has been drafted in accordance with the provisions of the UNGPs and encourages responsible business practices to protect human rights across the entire supply chain. Next, Japan. Japan's human rights due diligence landscape is characterized by a soft law approach and a robust set of government guidelines with a strong commitment to the UNGPs and the OECD guidelines, but still without binding human rights due diligence regulations. The 2020 National Action Plan aims to improve business understanding and awareness on human rights and encourages companies to embed a human rights policy and due diligence processes. On 1st October this year, the government launched a public consultation on the revision of the National Action Plan, which will remain open until 30 October. The aim is to include new provisions on artificial intelligence and environmental issues, and also to encourage companies to disclose information on their measures to respect human rights and the implementation of due diligence system among small and medium-sized enterprises. In addition, the government issued the guidelines on respecting human rights in responsible supply chains in 2022 and published some practical reference materials in 2023. The guidelines aim to apply to all business enterprises operating in Japan, and it is expected from them to adopt a human rights policy, implement due diligence systems, disclose information on the risk and measures implemented, as well as to provide effective remedies such as grievance mechanisms. Since April 2023, the government has started including a clause in public procurement contracts requiring companies to respect human rights and to follow the guidelines published by the government. It's important to note that even though that the guidelines are voluntary, over 70% of Japanese companies have implemented at least a human rights policy, and some of them require suppliers to also be compliant with the guidelines. Just really fast, the 2023 reference material provides in-depth explanations and case examples that help implement the guidelines, including how to establish the human rights policy and identify and assess product and sector-specific human rights. For example, in the manufacturing, chemical, and oil and gas, or respect to products about apparel, textiles, and minerals. Specifically, it provides steps to identify the areas of a supply chain where high risk arise or may arise. For example, it includes a country classification and risk index for child labor, in which Somalia has the highest risk and France having the lowest one. Taiwan. Taiwan, like Japan, follows a soft law approach with a strong commitment to the UNGPs. There are still no binding regulations yet, but a national action plan was approved in 2020 and it's currently being updated. Since early 2024, the draft of the second version of the National Action Plan has been developed in parallel with the famous guidelines for enterprises to respect human rights in the supply chain. It aims to encourage companies to embed human rights in their day-to-day activities and establish human rights due diligence procedures. Indonesia. Currently, Indonesia does not have any binding human rights due diligence regulations yet. Instead, it issued a national strategy on business and human rights in 2023. It is based on the UNGPs and provides guidance to all business actors in Indonesia, excluding foreign companies, and encourage them to adopt the human rights and business risk assessment model that is the PRISMA application to identify, prevent, and mitigate human rights risk. On the other hand, online reports indicate that the government is currently drafting new regulations that are intended to establish mandatory human rights due diligence and sanctions for non-compliance by 2028 at the latest, with a pilot program involving large companies and state-owned enterprises. China. China is another example of not legally binding regulation, but a complex set of government guidelines and a trade association recommendation. China has implemented and formulated 3 action plans since 2009. Currently, the one that is in place is the 2021 to 2025 National Action Plan, and in particular, it encourages business to abide to the UNGPs in their foreign trade and investment and to conduct human rights due diligence. The second edition of the Chinese guidelines for mineral supply chains was published in 2022. This also helps all Chinese companies involved in the mineral supply chains, whether upstream or downstream of the value chain, only excluding service providers. Major changes have been made in terms of structure and content compared to the previous edition. 10 characteristics of the due diligence have been incorporated in line with the 6-step OECD due diligence guidelines for responsible supply chains of minerals from conflict-affected and high-risk areas and the UNGPs. Finally, the document also adds new minerals to the list and enrich the type 1 risk related to conflict-affected and high-risk areas, and the type 2 risk related to social, environmental, and economic issues. In third place, we have the National Textile and Apparel Guide on Social and Environmental Due Diligence, which is a sector-based tool for enterprises to identify and manage their own social and environmental risks and those of their supply chain. Australia. Similar to the UK, we have Australia as one of the early adopters of a modern slavery regulation in 2018. Under the Act, large entities operating in Australia with an annual revenue of at least 100 million Australian dollars are required to submit a modern slavery statement describing their actions they have taken to address modern slavery risk in their operations. It is important to note that the Act is limited to modern slavery risk, and so no other human rights are included. Similarly, although businesses are required to report on how they are addressing this risk, they are not required to have due diligence systems in place, and there are no penalties for non-compliance with the mandatory requirements. This is likely to change as the government launched in July 2025 a public consultation to amend its regulation, which arises from the 2023 Statutory Review report recommendations. The report recommendations include introducing penalties for non-compliance, amending reporting requirements, and implemented a due diligence system. It's important to note that this consultation focuses only on the reporting requirements, compliance, and enforcement. Regarding the implementation of a due diligence system, the government will conduct targeted consultations with specialists later on, but no date has yet been established for this. New Zealand. New Zealand appeared to be a country willing to implement legislation on modern slavery with a consultation in 2022 and a government plan announcement in 2023. However, progress has been halted since 2024. 2 private members' bills were introduced and seem to reignite New Zealand efforts to adopt new modern slavery legislation. The drafts, similar than the UK and Canada and Australia, sets disclosure and due diligence requirements for companies, whether local or overseas, operating in New Zealand with annual revenues exceeding 50 million New Zealand dollars. Similarly, they would include provisions for establishing an anti-slavery commissioner and economic penalties of around 200,000 New Zealand dollars for non-compliance. Unfortunately, these bills have not reached the mandated threshold for them to be formally introduced into the House. South America. The Human Rights Framework for Business bills introduced in 2022 mandates all companies operating in Brazil, regardless of the size or sector, to conduct human rights due diligence. The obligation extends to their global subsidiaries, branchers, subcontractors, and suppliers throughout the entire value chain. As a result, companies are required to implement due diligence systems to prevent, address, monitor, and remedy human rights and environmental abuses. This includes adopting a policy statement and submitting biannual reports detailing their implemented actions. The bill is still under discussion in the Brazilian Congress. Then Chile. The Chilean Senate introduced a proposal to regulate corporate due diligence concerning human rights, environmental protection, and climate change. To do so, the bill will require companies to prepare annual reports regarding the actual and potential risks to human rights and the environment, the protocols to prevent discrimination, violence, child labor, forced labor, and also an adoption of a climate plan transition to mitigate climate-related impacts. It will apply to large companies defined as those with 200 or more employees, with annual revenues of at least 60,000 monthly tax units. That would be approximately $4,300,000 US. Colombia. More recently, in July 2025, Colombia introduced its draft law on human rights framework for companies. This regulation targets all companies engaged in economic activities in Colombia and obliges companies to prevent human rights violation and disclose information. Finally, United Nations. There's a draft in the United Nations since 2014. The last version was released in 2024 during the 10th session of the UN Working Group. The draft aims to apply to all business activities, including those of transactional characters, and will require state parties to adopt legislative and regulatory measures to adopt a legal liability system for human rights violations and ensure business to respect human rights and adopt due diligence processes. These due diligence processes will have to include a regular publication of human rights assessments, the incorporation of a gender and age perspective in these due diligence processes, and undertake meaningful consultations with potentially affected groups, as well as to protect the safety of human rights defenders, journalists, workers, and those who may be subject of retaliation. Currently, the last thing, there's the 11th session of the UN that is taking place until October 24, and they might release a newer version of this draft. Now I will hand on to Joanne for conclusions and final remarks.
Thank you so much, Christian. Thank you. That was fantastic. So I'm conscious of the time. So again, just to wrap up, I just want to leave you with some key takeaways. First and foremost, I think it's pretty obvious from what Christian and Hannah have just gone through. Human rights due diligence is no longer a nice to have compliance topic. It is very much a must have legal, commercial, reputational imperative. The global regulatory landscape is shifting fast, as we can see, and it is easy to be somewhat blinkered by the ongoing simplification efforts in the EU and the deregulatory initiatives at US federal government, and particularly everything that's going on here in the EU with the Omnibus. But I think it really is important to stress that the direction of travel in the world is really, really clear. Human rights due diligence regulations and the enforcement of those regulations is increasing. Penalties for non-compliance are increasing, and they are increasingly being linked to global turnover, as Hannah covered. Some countries are even introducing criminal sanctions for non-compliance, and litigation for violation of human rights by companies is also on the increase. So all of that has all the, the negative financial, legal, reputational repercussions associated with those. One of the common threads, I think, that runs through a lot of the regulations that Hannah and Christian have covered is supply chain transparency. So supply chain transparency is in turn being driven by data-driven due diligence, the 2 Ds, as I call it. So as regulations are increasing, it's really, really important for companies to have robust data and documentation mechanisms in place in order to demonstrate compliance with all of the different national and regional due diligence requirements that Hannah and Christian have gone through. But at the same time, I think it's really important to stress that human rights due diligence should not be viewed as a tick box exercise. You know, a data-driven human rights due diligence approach, it really allows companies to track the efficacy of their due diligence measures and to communicate them to stakeholders. So it builds, you know, this transparency really does build accountability as well as trust. One of the second last takeaway there is that it is really important to remember due diligence, human rights due diligence is cross-functional. And that really, you know, when we're out there speaking to our customer base, the most successful companies, they ensure that human rights due diligence sits at the intersection of compliance, of legal, procurement, ethics, HR, sustainability. So, you know, that's why the real winning organizations, they embed human rights due diligence in their contracts, procurement policies, supplier onboarding, etc. And then finally, I suppose the last and perhaps, you know, the most important key takeaway that I want to leave you with this today is that human rights due diligence success really depends on staying ahead of regulatory changes. So the companies that are thriving and that are the most successful in ensuring a robust human rights due diligence process are the ones that build dynamic compliance programs powered by horizon scanning and regulatory mapping tools such as those that we offer here at Compliance and Risks. And the reason is simple, you know, you cannot manage what you cannot see. So it's really important that companies not just react, but that they anticipate in advance. So I appreciate we've gone through a huge amount of information here today. So I want to thank you all so much for taking the time to listen to us. And I'm going to pass you over to Orla, who's going to close off the session for everyone. So thank you.
Brilliant. Thank you all so much. And thank you to Joanne, Hannah and Christian for that fantastic presentation. Definitely a huge amount of information had to be covered in this session. And as a result of that, we're really close to the top of the hour. So very conscious about the time. We've had a lot of questions come in, but based on the time, I will advise the team to follow up with everyone who submitted a question directly. So if you have submitted a question, we'll reach out to you after this webinar. And if you've yet to submit a question, please do so now using the Ask a Question widget to the left side of your screen. And our experts will follow up with you directly, and we'll also share the full Q&A list with everyone. So yeah, really important. If you have any questions, definitely submit them, because it's a great one-on-one interaction with our experts. Just as I wrap up, I want to take a quick moment while we're on the topic of sustainability to introduce our new platform, Sustainability, the first native compliance intelligence built for corporate sustainability teams. And this platform helps you pinpoint regulations that matter most, including a lot of the ones that were mentioned today, generate tailored compliance obligations, and stay ahead of fast-moving ESG changes all in one place. So yeah, all of the most important ESG topics, including what was covered today, ESG reporting, climate disclosures, and many more are all housed within this powerful tool. And right now you can start a 30-day free trial by clicking on the banner at the bottom of your screen or through the Compliance and Risks site. So it's definitely worthwhile checking that out if you haven't already. And if you'd just like to learn a bit more about this new tool, we do have a webinar on October 30th that will show you how we're building smarter, more intuitive tools to anticipate your sustainability compliance needs even before they happen. And yeah, again, I just want to thank you all so much for tuning in with us today, and we really hope you found it helpful. Thank you so much again, Joanne, Hannah and Christian, for the huge amount of research that goes into these presentations. And these slides will be made available to you all. So it's definitely worthwhile looking through them. There's a huge amount of information that were barely even touched during this webinar to show the amount of changes that have happened. So yeah, definitely do take a good look through the slides as well after this webinar. We do look forward to seeing you in our upcoming webinars, as you can check out the resources section on our website to stay updated and to access our latest white papers, blogs, and of course our future webinars. We also have a lot of on-demand webinars there for you too, if you want to have a look back and watch them in your own time. And yeah, as mentioned, our next webinar is Introducing Sustainability, the Next Era of AI Native Compliance Intelligence, scheduled for October 30th. And we also do have another webinar scheduled for November 5th that's on our site, Environmental Claims and Legal Liabilities, a deep dive into anti-greenwashing regulations. So definitely not to be missed. And we hope to see you there. Thank you all so much again for tuning in with us today, and we hope to see you soon.